Now we're going to move on to another legal panel. This will be for 25 minutes called Launching an NFT Project Legally. Very, very important. I'd like you to welcome to the stage Yuliya, Prokopyshyn, Foulkes, James Burnie, and Krish Gosai. Thank you.
I'm not sure what's happened to my photo there. Ouch. Well, hello everyone. Thank you very much for coming to hear us speak. So, yeah, we're going to try and give you some practical guidance in this session. So we've heard a lot this morning on generally what the position is around the world, some key considerations, particularly from a US perspective. We'll all say who we are in a second, but we're UK and Australian based, and hopefully we'll be able to give you some really practical tips that you can act on after this session. But yeah, I suppose to kick things off, Yuliya, do you want to say who you are?
Sure. Well, first of all, nice to meet you all. My name is Yuliya Prokopyshyn, and I'm a solicitor at Stephens Law. I've been in this space for a couple of years, so I would like to think I know a thing or two about NFTs and how to launch an NFT project legally.
Great, thanks. I'm Will. I've been in this space for a little while now, I think back to 2016. Got very excited about blockchain technology and what it could do to change the world, particularly around financial inclusion. So I decided to go all in as a lawyer to the chagrin of several employers in between now and then. I'm still extremely passionate about it. I work with the Law Commission in the UK, so actually trying to shape the law and where it's going in this country. I act as advisor to several different boards and panels. On the other side, I also have my own company with this nice gentleman down here, Steve, called Stability. So we're trying to solve the problem with carbon offsets, putting them on chain and creating a bit more trust there. So I like to think I have quite a good understanding of the technology as well as some understanding of the law. James?
Hi, I'm James. I'm a partner at law firm Gunnar Cook, which is the only major law firm currently accepting payment in crypto. We cover UK, Germany, and US. Personally, I've been involved since doing the first successful initial coin off in the UK, first execution on chain, and recently worked with the Mauritian regulator, the Mauritius regulatory framework for crypto.
Hi everyone, I'm Krish, I'm managing partner at Gosai Law. We're an Australian-based law firm specialising in cryptocurrency and financial services. I act for 3 of the top 80 cryptocurrencies by market cap, everything from financial services regulatory all the way through to, in relation to NFTs, so launching decentralized marketplaces, NFT marketplaces, using NFTs within ecosystems and games. So yeah, pleasure to be here.
Cool. So then to kick things off, we're going to try and do this in broadly 3 areas. So what sort of things do you think about from a structural point of view if you want to launch an NFT project? Where should you incorporate that sort of thing? Krish is going to talk about. Then we're going to talk about commercially, what sort of protections do you need to put in place from a contractual point of view to make sure that your rights are protected, you're doing everything safely. And then James is going to probably not scare us, but talk about regulation and what you need to think about in that respect. So Krish, let's say I came to you now as a client. I don't live anywhere. I float around. I'm a nomad. And I want to launch an NFT project. What are some of the things that I need to think about to do that from a structural point of view?
I think this sort of goes hand in hand, and we've heard for most of today about the regulatory ecosystem and uncertainties within different jurisdictions. So the considerations are sort of based on that. It's one, where do you want to launch your project, first and foremost? What regulatory environment applies and what ecosystem or jurisdiction applies to that? What laws do you have to comply with? So, if it's in the US, there's obviously the SEC considerations, UK financial products and financial services laws, same thing in Australia as well. If you don't live anywhere, it gives you flexibility, right? You can choose a jurisdiction that's favorable, which either has or doesn't have legislative regulations around crypto assets. And for what that does, it gives you options and flexibility. So say, for example, we choose, say, BVI, right? BVI, at the moment, they may look at getting VASP laws in the near future, but at the moment, it's a jurisdiction that everyone sort of looks at, and it's a safer jurisdiction for launching a project. So we'd want to look at where do you want to issue the tokens out of, what, NFT or the fungible tokens, where do you want to issue that? And issuance is probably the first and foremost what regulators look at, is what entity is issuing it and where are they issuing it from. So if we choose that as the BVI, then you comply with the laws there. That's not the only thing you need to sort of be aware of, though. Practically, you have your business operations as well. Who are you going to be in business with? Other founders, other team members, artists that you may work with, marketing team, etc. So really structuring your business goes further than just the regulatory considerations, but also internal corporate and commercial considerations as well. So looking at your structure, intellectual property is huge, right? So do you want to have a separate entity that holds the intellectual property? And what happens from that entity as well? So that entity has the intellectual property. Do you have another operating company that then is the vulnerable company where that has the contracts out with third parties, that actually organizes and does the marketing activities from that? Licenses agreements between those entities and services agreements between entities of high risk and low risk activities. So those are probably just some of the considerations there. And then when you look at internally with your business partners and other team members as well, how do you incentivize your team members, right? Are they employees? Are they contractors? If they're employees, what jurisdiction? Where are they based? I guess, do you have to pay superannuation or taxes on some of those payments as well? Who's obligated to do that? And internally with shareholders, and because a lot of times you have a company set up, so you have shareholders within it. And what I've seen is that that's probably where most of the internal disputes occur, right? You have falling outs with founders, and you have other issues between other team members as well. So having a solid shareholders deed or shareholders agreement where everyone knows what their responsibilities are, what their rights are, what they can and can't do within the business, that sort of prevents disputes later on. And when we talk about launching a project legally, I think it's a holistic view that everyone needs to have, not just the regulatory side, but also internal considerations for running the business as well.
That makes perfect sense, thank you. And so dialing into a little bit into what you said, could you give us some steps of what you need to do if you wanted to incorporate a company in the BVI to launch a project, practically?
Yeah, a lot of the times when I'm doing this, we'd use agents in the BVI as well. In the BVI, one of the considerations is economic substance, right? So whether you actually have onshore staff or business operations in the BVI, so we'd ordinarily look at, if the reason why we'd use the BVI and separate there instead of just running your home jurisdiction is to separate risky activities, right? So we'd look at what are activities that are somewhat regulated and that could potentially get you in trouble, chuck that into a BVI, chuck that offshore into a separate entity, and then keep things that are sort of fine, like marketing activities, software development. Those are things that are pretty uncontroversial. You can keep that onshore. So if you're in the UK, keep that onshore. Then you have your services agreements between the two and internal contractual relationships between the two. So setting up in a BVI, one will be, let's find a good agent, a BVI agent there. That's probably the easiest way to do it. They turn around companies within a couple of days, doesn't cost too much. We need to work out who the shareholders are going to be, who the directors are as well for that. So, whether you personally want to be a director there, or you can have a company as a director in the BVI, or do you just get nominee directors, right? Especially for risky activities where, you might not want to have you personally on there or your entities personally. It might be a good idea to get a nominee director. And that's really the process, the early stage process that we usually talk about when setting up overseas.
Brilliant. And do you find it's relatively easy to find BVI-based nominee directors that want to do crypto asset-based activities?
Yeah, definitely. I think cool. The BVI is somewhat becoming a hub for crypto as well. There's a lot of projects running out of the BVI. So there's a whole bunch of people over there that are sort of professional directors. They just want to know what your business is. So, being open and telling them about your plans and what activities you're sort of running, if it's an NFT marketplace, if it's a game, if it's just JPEG images, for them to have an understanding of what your project is, they're more than willing to become directors of that as well.
All right, thanks so much, Krish. Okay, so now you have an idea of where you might want to set up your company and some of the key things you need to do to do that. I want to know why you're laughing. And so then
you're here for Poland.
Yeah. You're actually now ready to launch an NFT project. So Yuliya's now just going to talk to what are some of the key things that you should put in place to make sure you do that safely.
Sure. So I think one thing that I try to explain to a lot of clients that when you try to mint and launch your NFT collection online, it's not as scary from a legal perspective because the set of documents that you need to put in place is usually quite similar to different goods or services that you try to sell online. And one of the things that we usually ask our clients is first to understand whether they're planning to launch their NFT collections through their own platform or marketplace, or whether they're using third-party marketplace, because the set of documents will slightly vary. So let's take, for example, you have your own NFT marketplace and you want to launch your NFT collections through it. So you usually would need to have the following things. First of all, it's terms and conditions that explain to your buyers and users how to actually mint, sell, or purchase NFTs, whichever functionalities your NFT platform has. And it will also cover different risks associated with NFTs as well as blockchain technologies and try to limit your liability as much as possible. The second document, which I also think is probably the most crucial in this situation, is going to be NFT terms of sale. And this document would not only govern the relationship between the buyer and the seller of NFT, but also set out all of the IP rights attached to the NFT. As most of you in this audience probably know, when you buy NFT, you don't actually buy the thing what is on that NFT. So, for example, if you buy an image of a moon, you're obviously not going to own a moon. So it is quite important to have that IP license that both the seller and the buyer clearly understood who's going to own what after the sale of that NFT. And if you are an NFT collector, creator, this is something that you probably should discuss with your solicitors or lawyers in your country, because they're going to be able to explain to you what rights you can give, what rights you can keep, and usually it is a simple license where the owner keep all of their IP rights to the NFTs and the buyer simply gets the license to them. However, it's totally up to the seller to decide which rights they want to give to that NFTs, and if you want to totally assign all of the rights to the buyers, you can totally do that. The other document would be a privacy policy, and this is a very big misconception by a lot of NFT platforms, assuming that they don't need to have a privacy policy just because they think they don't collect personal information. However, at the moment, most of the jurisdictions use digital wallet addresses as personal data. That's why if your NFT marketplace is collecting digital wallet addresses, you would need to have a document documenting how you actually process and collect the personal data. And the last document would usually be different NFT services or collaborator agreements. If, for example, you engage some artist to create an artwork for your NFT collection, which you're later going to use, or, for example, if you work with any third-party providers. So this is something that you would need if you launch your NFT collection through your own marketplace. And if you launch your NFT collection through third-party marketplace, this process is usually so much simpler, as the only thing that you really need is going to be that NFT terms of sale, including the IP license. If you're a very prudent NFT collector creator, you would also make sure you check the terms of the third-party marketplace where you're selling your terms. I understand that this might be quite overwhelming for someone who wants to launch the collection, and as one of the previous speakers said, we much rather help you with all of these things before you actually launch. But there are situations when you either already launched your collection and you needed your documents like yesterday and it's not possible, or you don't have time to prepare all of that. If you had to focus on one thing, just make sure you have this NFT terms of sale, including those license, so that you as a seller kept all of the IP rights to the NFTs that you wanted to, and also gave the necessary rights to your buyers.
Perfect, thank you so much. Yeah, that's a really key point, and that's a lot of what we talk to clients about is around the IP side of things. As we're starting to see now, NFTs, obviously we're transitioning away from just PFP uses, and people are starting to do a lot more, like incorporate them into films and games, and like people need to do something with their apes. So that is understanding what rights you get as a buyer, if you're doing that, or if you're selling them, what you're willing to give away from a commercialization point of view. Like, are you willing to let people commercialize this up to a certain cap, unlimited, etc., on certain contexts and not certain other contexts, etc. But that was great. Thank you, Yuliya. And obviously, we can help you with that. If you need that, we just have a menu of things that you need if you want to launch a project. I'm going to move over to James now, if that's okay, James. Pick up the mic. I've got a very specific question. I'm not going to ask you, isn't NFT a security in the UK, because that would be mean. But if you were launching, again, same theme, launching an NFT project, a lot of these are exchanging NFTs for money, and they are, in a way, then raising money through the sale of their NFTs. Does that mean, or what are the key considerations that they need to think about then?
I'm going to let everyone into a little secret. There's 150 countries in the world. There's one United States. Every United States story will tell you how complicated, difficult, and awful it is, and it's all very grey, and it's true in the United States. Other countries, it's much, much easier. And what you walk into, there's basically 3 regimes to be aware of. There is AML and KYC. That's where you're based. Now, flavor of the week is BVI as the most dodgy, the least dodgy, most dodgy jurisdiction. You can get it to work, yeah. But it is got slight red flags, but not enough to turn off everybody. Option 2, Germany. No one talks about it because nobody particularly wants to go down that route, but it's actually a gorgeously simple route because you don't need to have any licensing whatsoever. You pair up with a German bank and you're up and running in a couple of months. Very quick, very cheap, access to the whole of Europe because you've got the great German sense of humour marching boots helping you as you go to other European jurisdictions. You then have my personal favourite, which is the SODIT jurisdiction, known as Panama, where they go, what is KYC and AML? And we set it up, and we go, we may or may not be here in a couple of years, but yes, let's go for it, if you see what I mean. Panama is the top jurisdiction for video games, because if you don't do a full KYC background check to play Super Mario Brothers, why are we doing it to play a video game? It's one of life's great mysteries out there. The second area to look at is the so-called securities regime, where we all look at things, and all lawyers looking cringe and go, like $1 million to give you an opinion. Now, the $1 million opinion moment is usually in the US because they have a thing called the Howey test. It's all very broad. Somewhere like the UK, it's really quite clear and easy. It is not that difficult. And in fact, we have another advantage, which was written by Monty Python in certain parts. Let me give you an example. I have a token, and I want to give you a link. I want to give you a return if you hold my token. Now, if that return is variable and linked to the exercise of discretion, you have a collective investment scheme, you need 10 million, professional investors only, your client bloody hates you. Let's change it up. Let's give everyone a fixed rate return. In fact, let's just be a bank. Yeah. Now, a bank is defined under UK rules as an entity which borrows money and lends money. Key word, money. So if you basically act like a bank, but don't call yourself a bank, because that would be a criminal offense, bit of a blow, but if you act like a bank and you keep it in crypto, because it's not money, it's not regulated. And that's where if you get it right, it's amazing how you can create value for people who are involved by just getting it right to come in. But it is not the grey soup cooling moment, you've just got to get it right. The third area is the future. Now, there are a couple of things for the future. Now, the UK, we're currently, the FCA are hiring roughly 100 people in the UK to speed up the applications process in the UK, so it's going to get quicker and easier. And there are 2 areas to think about on the UK side. The first one is around stablecoins used for payments, which no one in this room is going to give a monkeys about. And the second one is going to be around advertising crypto assets into the UK, which you're going to look at and go, it's all fine, but it's not fine, but it is fine. Because at the moment, what you've got is those rules are taken from the more securities angle. Now, they are being applied, as it's currently written, to fungible tokens. Your problem is all the fungible token guys are now going, we're going to become an NFT. And we're going to sort of call it an NFT and we'll get outside the rules. And we don't know where that's going to end. But we've been talking to guys like in other countries, and it's clear that most regulators are going to go for some form of advertising regime. And it's a question of don't say anything stupid, which is very easy to say and much more hard to put in practice. But that's the one thing about it. But again, that's the direction of the future, and that's the thing when you're going in. And the reason that's coming in is because our gorgeous BVI loophole that we all know and love is coming to an end with that regime coming in to try and block it. So it's about keeping it right for today and keeping it right for tomorrow.
Thank you, James. That was brief but intense. Thank you. I agree. We have 5 minutes, and I think we'd like to open up to questions to see if you guys have got anything that you'd like to know about. Yeah, what we're talking about. Anyone? I'm not seeing any hands raised, actually, so no questions. Okay.
Anyone in the room interested in DAOs? So the UK is heading towards creating a bespoke framework. I'm giving myself a piece. Is that all right?
We can go for it, yeah.
The UK is talking about, and Will, I know you're involved in this and we're involved in this, but there's a new framework for DAOs coming out. Now, I like DAOs because DAOs are quite interesting. So there's a throwaway statement at the SEC which basically said, Ethereum is totally not a security because we can't lock everybody up. It's a standard regulator of throwing the towel type moment. We have the same in the UK around money laundering, where effectively, if you take the extreme view, everyone who's ever held a Bitcoin is held in the process of crime because the original Bitcoin was actually an act of treason, which is a blow. So I asked the FCA if they're going to lock up everyone in the UK who'd ever held a Bitcoin, and they told me to shut up and stop being a pain in the ass. So the question then becomes around the DAO question, because if you create a DAO, can you be decentralized enough not to be a security under US laws? The second reason you want to do a DAO is to get greater community engagement. And then you go, well, I'm going to set up the DAO. And the reason we're both interested is at the moment, you've got two countries. You've got Wyoming, which is in the US, and very cold, apparently, because every time I suggest to my American clients they should just go and relocate to Wyoming, they basically say nasty things to me. The second area is Marshall Islands, which is just not big enough to get it to work, and they don't have the infrastructure behind it. So in the UK, the conspiracy is to get the UK to recognize DAOs as a structure in their own right, which means the UK would be one at the forefront in terms of having those sorts of structures in place. And it's part of a sort of broader government thing at the moment, which goes in the press, the Crypto Hub, which sounds like great PR, but it's kind of the specifics. And I think, well, you had one also on the Companies Act as well.
Yeah, I was just going to jump in then. So if you are getting involved in an NFT project and there is this talk of a DAO, the risk that we would address by making this change in the UK is that currently at the moment, you all kind of have unlimited liability if you're a participant in a DAO. So if the DAO does something, if it does something that is in breach of one of these myriad of laws around the world and gets subpoenaed and sued and there is a fine, whatever, that could be meted out against everyone in that DAO. Like you could all be gone after. A lot of people don't realize that. So what we're looking to do is create some kind of a limited liability structure, which currently doesn't exist, apart from in Wyoming, sort of. But to do that with a good English law precedent so that you can participate in these things and not be on the hook. Because there are so many projects now that are trying to do good, trying to use this technology to create a more democratic environment, promote an artistic project or something like that, and inadvertently are actually creating a huge amount of liability for all of their participants without realizing it. You had a question at the back. That's absolutely fine. It's not what we're supposed to talk about.
So, from a legal point of view, if you're a B2B2C organization, okay, so as a service you provide NFTs for a customer, let's say Coca-Cola, and Coca-Cola then gives the NFTs away for free. So the initial business sets them up, they make money from them, but they don't own them. Mm-hmm. Who's liable? Who's the onus on?
Depends how smart your lawyers are. The way to get it to work is enter into an IP agreement between the B2 business and the Coca-Cola business, get the Coca-Cola business to create the token. The Coca-Cola business then gives it away for free. Because it is free, the law basically says you're a muppet rather than regulated, because no law can get their head around why anyone does anything for free, because we're lawyers, and therefore you're outside of all the regulatory regimes. In terms of who is liable, Coca-Cola is the most likely to be the customer-facing institution. Coca-Cola will then take the primary point of liability, because if I get stroppy, that's who I'm likely to sue. Depending on your size, depends on the agreement between you and Coca-Cola. And this is where you enter into comedy moment. Because what will happen is Coca-Cola's lawyers might well turn around and go, we want you to totally indemnify us against any loss ever on Earth, forever, if you see what I mean. You'll then turn around and go, great, we'll have more money, please, to reflect the risk. Coca-Cola will go, ouch. And then what you'll do is take all the money out of that company, because you're a startup, so you just pay it to yourself and spend it on stuff. So they pay a huge premium to achieve absolutely nothing in terms of their additional protection to get hammered later on. If your lawyer's a muppet, you might go a completely different answer, but that's how I would approach it.
I'll just jump in quickly. I've done a couple of these where we've had licenses from a sneaker company for an NFT gaming project as well. It all comes back to the services agreement that you have, and it's probably a tripartite agreement that you have as well with some of these entities, and the terms that you have within those agreements, like the indemnity clauses as well within that, to sort of outline the roles and responsibilities of each party as well.
Does that make sense? Yeah, and the main thing is limit your liability to get a lawyer to help you draft that contract, which is what we're talking about. Okay, I think we're out of time there, guys, so thank you. You've been great.
Thank you.
Love you, London.
Thank you very much, guys.